Here. All right. Well, welcome everybody to this fabulous Tuesday. I want to thank everybody for being here with Blue Star and Relativity for the double-edged sword of AI and law, mitigating risks and upholding ethical standards. It's a very big topic. It's a very hot topic. And we've got an amazing panel with amazing information for you. My name is Deirdre Sorego. I am the Director of Marketing here at Blue Star. This is going to be a CLE credit. So it's a CLE that'll discuss what attorneys need to do to comply with American Bar Association rules of professional conduct as it applies to artificial intelligence. This credit is provided by Relativity. So at the end of the panel discussion, or towards the end rather, we will reveal a secret code that will be your CLE code in the chat room, and then that you'll give to Relativity, and then they will give you your credit for today. I do want to thank Relativity and, of course, Blue Star for today. We are your sponsors for today's webinar. Blue Star is for 20 years. Blue Star has been a trusted partner for e-discovery, litigation, and e-discovery solutions and data solutions, providing tailored and innovative services to corporate law and law firms worldwide. Relativity also makes software to help users organize data, to discover the truth, and to act on it. So a little bit of housekeeping. This is going to be an hour-long CLE. There's a lot of information, like I said, so we're going to try to cover any and all and as much information as we can. The panelists would like you, if you do, feel free to answer they will be asking questions throughout the CLE. We would like to hold all questions for the last 10 minutes. So please write down your questions or keep them in the chat, and then Donna will read them towards the end of the CLE. Without further ado, it is my pleasure to introduce Donna, and then Donna will introduce our esteemed staff. Donna Medrick is our moderator. She's our Senior Director of Legal Solutions at Blue Star, and Donna has been with us for 15 years. I will sign off. Thank you, and enjoy the show. Donna, it's all you.
Thank you, Deidre. Thank you for the great introduction, everyone. I am Donna Medrick, as Deidre alluded to. Ladies and gentlemen, distinguished guests and esteemed colleagues, I'm delighted to introduce to you our remarkable panel. These accomplished women represent the epitome of dedication, intellect, and tenacity in the legal profession. With their vast knowledge, diverse experiences, and unwavering commitment, they inspire us all to strive for excellence and uphold the highest standards of integrity. Please join me in welcoming these outstanding women as they share their wisdom and insights with us today. First to my right is Brittany Rouse. She is AI Search Development with Relativity. I have Tanya Brown, Senior Discovery Counsel from Perkins Coie, attorney, Senior Discovery Attorney, sorry. Angie, thank you. Angie Gomez, she is Senior Corporate Counsel with Cleveland Cliffs Steel. And I will begin if that's okay, ladies. If I may, what would you say, panel? How would you define AI and the use of it in legal? More importantly, how do you define AI? We have a couple people.
Oh, never mind,
Thank you.
so if I can, so AI is a way to describe different models that are able to act independently and provide information. In some cases, they're used for decision making. That's autonomous. But we could discuss that more, but it's very distinct from some of the other kind of terms that you'll hear, like machine learning, which is requiring human input. It's semi-autonomous. And then you have deep learning, which doesn't require any sort of human intervention, fully autonomous, but it's not really bubbling up decisions, or it's not really giving you suggestions on things.
Excellent, thank you. It is the 21st century fact that efficiency, agility, competitiveness, and growth hinges on the successful use of AI. I'm excited today that we will be discussing the Model Rules of Professional Conduct by the American Bar Association, and we will begin with duty of competence, Rule 1.1. I will not be going through the entirety of the 5 rules that we're highlighting today, audience. Just be mindful of that. It will be in your takeaway or your written handout after this event, if you'd like to look at it more closely. Knowing that AI and legal, the sky's the limit, whether it's technology assisted review, other analytics and e-discovery, due diligence, contract analysis, etc. Panel, please tell me, how have you been using AI?
Broad question. Using it extensively and in a number of different cases where it's basically been identified as the best way to be efficient and to save cost and to basically deliver the best possible product for the client in a timely fashion. And again, with the cost being taken into consideration, using structured analytics, machine learning to a degree, active learning, basically all the different types of ways you could think of using AI are really prime for the legal field. If you ask me, basically, I think that, if we could just break down the components of machine learning, right? That's one that I kind of thought about a lot. You have a algorithm or set of algorithms, you have a data set, and you have a model. And essentially, all of those things are basically a lot of how we work in the e-discovery space in particular with respect to AI. So it just is a natural fit, using it in a lot of different cases, but the case must be a good case for it, especially on different platforms. Say, for instance, relativity. You make sure your data is the type of data that the text can be analyzed. Make sure that you have actual clear-cut positive and negative choices where the system won't be run awry by a bunch of coding differently, which could skew the system. And then that you make sure that you have a data set that you basically can utilize it on without it causing more problems on the back end. So.
Excellent, thank you. And I love that you highlighted for those that are not involved in e-discovery, they're always shocked when I say, oh, Blue Star, we've been using AI for almost 10 years. And I'm like, well, it really goes hand in hand in the e-discovery space.
1.0, 2.0, 5.0.
Exactly. Angie, tell me a little bit how you've been using AI in the wonderful world of legal. You've had a wonderful career in legal in a variety of roles. You're a newer attorney. I'd love to learn more about your experience.
So our company tends to use it like reviewing contracts, finding documents, conducting legal research, sometimes drafting contracts, but more so in e-discovery when we are in litigation. We utilize AI to collect all the emails and data available because now everything is communicated, or most things are communicated through email. Everything is uploaded and is digital now to be able to search and find relevant documents pertaining to litigation, and that could be extremely costly. And I mean, for the legal review, a legal attorney review of all those documents would be in the hundreds of thousands, if not millions, depending on how many custodians we have. So currently, like, we use AI along with like Blue Star, who educates us on new software development to help us manage and shift through all that data and to be more cost effective as well as like timely in our responses because we all have deadlines to meet.
Oh, excellent. I appreciate that. And that's true. I mean, Richard Susskind, renowned legal expert, does go at great lengths in '96. And I didn't know this, but he was threatened and so forth by saying that email communication would be prevalent in the legal industry. So it wasn't that long ago, right? And then for a lot of us, cloud computing, that was resisted, I guess, as well by the legal industry. There was much resistance, being a risk-averse society, if you will. How about the idea of data storage in 1980? Storage would be around 300,000. And now data storage is significantly less, in some cases free. If I may, Brittany, I'd love to know what you think about open source and TensorFlow and how that gave rise to AI being used throughout society, not just legal.
Yeah, there's a undercurrent of like democratization around AI that I think is really special. You know, AI is not something that is unachievable to anyone. And there's a lot of tools that are enabling people to now become much more familiar with it and being able to build their own models. In some cases, like Microsoft just announced that you'll be able to build a model powered just off of what's on your laptop, like in terms of memory and RAM. So I think the open source movement really helped with giving the platform for information that was required for the innovation to rapidly excel and to share. And if you've ever worked with developers, you know that they love to share code and share ideas and really like push on what can be built. The flip side is maybe what should be built, but I think that's a conversation that we're now starting to have.
Thank you. I appreciate that. When it comes to the ambiguity of AI legal, what are some of the names that you've heard of, panel? I can think of like 12.
Well, I can start.
Please do. Thank you.
You know, I've worked in the e-discovery industry before I went to Relativity, and I worked for Navigant, where we had a competitor to active learning. I can't remember what we called it, but it was some, you know, fuzzy name. But active learning, TAR, we have review center now at Relativity, TAR 2.0, you know, TAR whatever. And then, but it's really fascinating because at the end of the day, these are very specific models that all have their own names. So if you get somebody who's like aware of this, then you'll start getting into named entity recognition, and you'll start getting into sentiment analysis and categorization and classification. So AI, which covers more than just AI, is such a broad umbrella, and there's so much underneath it. Like I'm still learning every day about new kinds of models, new kinds of embeddings, and new ways to do the automation that we're all seeking, regardless of whatever that is called.
Yeah, I always found it confusing with cognitive computing, continuous active learning, TAR, you know, analytics, advanced analytics, technology assisted review, predictive coding, and the so forth. The interchange, it's how it's interchangeable. Like you said, they're vastly different with being semi-autonomous as well. Thank you for sharing that. And audience, forgive me, I failed to remember I'm doing the slides. So we're back up to where we should be in the slides, which is starting with the Model Rules of Professional Conduct by American Bar Association. We're going to start with competence. Forgive me. Okay, so for competence, I find this really interesting because there is no shortage of opportunity to learn. And I know everyone is starting at a different place. We mentioned that e-discovery was one of the first to get into the wonderful world of AI-powered solutions, but there are some that have yet to try any AI in their personal or professional life. Panel, I'd like to get some of your feedback. What do you think? What are your thoughts when it comes to competence? And not just for the law, but how the ABA specifies, the competence in technological tools. Angie?
So I don't know if most folks know, but 40 states currently have adopted a duty of professionals to be tech competent. It doesn't require us to be experts in the tech field, but it does require us to have a good understanding to be able to advise our clients the legal risks associated with AI, and so that they can make informed decisions relating to the litigation. It's a basic understanding, and most folks, it's available to all of us, if not through CLEs, also through our vendors and our software developers. If we ask, like, hey, how can I better understand this? Like with Bluestar, if I wanted to be educated on new technology, for most cases, you're very proactive with me, and you'll tell me, hey, we got this new tech available for e-discovery. I think you'd be interested. Let me break it down for you. Let me know when you have time to do lunch to go over it. And you always provide me with a ton of resources. So I think most folks, it's easily accessible to everyone, if not on the internet through your vendors and and your software developers that want your business and are willing to educate you to keep you up to date with technology.
True. Tanya?
To piggyback off of Angie, I think that if you do not possess the requisite skill to utilize the technology, it's incumbent upon you to bring in experts, bring in resources to make sure that you are able to, in case anyone didn't hear me, basically it's incumbent upon you to bring in an expert if you personally do not possess the requisite skill to use the technology that you're trying to use, because ultimately it will fall on you. And we will talk about that later with Bianca Airlines. So basically you have a duty either to learn it or to make sure you hire people or bring in people that know technology.
I liked also to point out standard of care. It's AI represents standard of care in the area of legal practice, but at this time, it doesn't appear to be necessary. Nonetheless, lawyers, as you ladies point out, must understand the technology, must understand the capabilities and limitations in the risks and benefits. Moving on, if I may. Communication. Duty to communicate. ABA Model Rule 1.4 governs a lawyer's duty to communicate with clients and requires a lawyer to reasonably consult with the client about the means by which the client's objectives are to be accomplished. I would love to know what the panel thinks about this particular rule. Who would like to begin? Tanya, you look like you have something to say.
It's the wrong face. I think that, do you want to go all the way down a rabbit hole explaining to clients things that you wouldn't go drag out exactly your process for doing legal research, for example. I just want to say what I think on it. But you could bring them into a certain amount of what you're planning to do, even if you don't give them every bit of it. Like, we're going to take a validation sample. We're going to call the set. We're going to throw it over here. We're going to put in structured analytics. Then we're going to cluster the data. Basically, just hearing the terminology makes people go, And you'll basically not benefit the client anyway, explaining things over their head and that they really don't need to know. However, I do think it's more important to communicate to opposing counsel as well as to the courts. And some judges are making that part of their orders. I was able to find in my research, one particular judge is making it part of their order, right? Yeah, it's an international trade court that you have to disclose if you're using ChatGPT to write briefs, basically. So you must put it, and I just found that yesterday. So I think the communication for me extends more to opposing and the courts, and a lesser duty in terms of the client, maybe the general counsel of your client. But, if you're dealing with like a personal injury case, how much can you really explain to an actual client in that sense? But, maybe tell them AI is being utilized. That might be enough. And, if the follow-up questions, then answer them. So, but yeah, I think you have an absolute duty to communicate to opposing and to the courts.
Yeah, it wasn't that long ago. You and I were just talking about that. It wasn't that long ago that a lot of individuals were not disclosing, and you mentioned how, oh yeah, can you imagine? I mean, you have to go all the way back and start all the way over, talk about not saving money, not to mention violating some of your ethical responsibilities as a lawyer. Right. So I love that. How about we discuss the role of black box AI, which we're going to discuss communication, consent, and so forth. Brittany, would you like to discuss what black box AI is for the audience who does not know?
Yeah, so black box AI is essentially what it sounds like you have no insight into how it's built, what assessments have been done on it. You're using something out of the box. And to a lot of extent, ChatGPT is like this, right? Like you log in, you put your query in, and you get results back. And that's the way that software has often worked in the past because of IP concerns and competition concerns and so forth. In the legal sphere, I don't, and this is my claim, I'm not going to say it, that I'm speaking for relativity here, this is me. I don't think black box should exist. And that's because the impact of what we do goes far beyond just, did we produce the right documents or not produce the right documents? These are people's lives that are impacted by what we do. And so if you don't understand what the technology you're using does, then you can not only violate your ethical obligations, but you can harm a person, and you have a duty of care there as technologists to not harm other people intentionally, of course, but also like I think there's some duty of care there about not doing unintentional harm or reducing that as much as possible. And so, when you think about communication, it's not just to your clients or the courts, which is absolutely important, but it's to the software vendors and pushing against like, how are you developing it? What are you using? What is your data set and so forth, so that you can make sure that you're informed about the technology that you're using.
Excellent. Oh, go ahead, Tanya.
I just found yesterday, a lot of stuff happened yesterday. Basically, a good way to explain black box AI. Basically, when I broke down the different aspects of machine learning, algorithm or set of algorithms, data, and a training model. Think of an autonomous driving vehicle. It hits someone. You would want to go back and trace why that happened. However, if any of those aspects of the machine learning are hidden, they're considered in a black box. Basically, if the training model, the algorithm, or the set of algorithms, or the actual data is hidden from the user or whoever's trying to get visibility into it, that's the black box, and it does not allow you to figure out why something happened, why something was done. And I think the autonomous driving vehicle is just a great way to understanding and kind of layman's terms, a little bit of applicability to law, but just, extrapolate over to law. And it's basically, if something happens and any of those aspects are not within your control or knowledge, that's the black box. I think that can be problematic, and I agree with Brittany on that aspect. There should not be in our arena a black box.
Under communication, what is automation bias? Anyone on the panel like to answer that for me, please? I think that's an important aspect of the opposite of a technophobe. There is
Yes.
automation bias, which is
Tendency to favor decisions made by a AI or a technology tool.
Do that?
Yeah.
No, it's not the news.
Over humans.
Sorry, a good example is Google Maps, right? You're driving and you're like, there's no way I'm turning right here, but you turn anyway because the robot told you to. Yeah, and like I work in this field and I do this all the time. So but in legal, you're like, oh, okay, my active learning project returned these documents that must be responsive, right? And the robot said so, so it must be responsive. But you can get yourself into trouble there, and that's where validation and compliance and making sure that you're following your own SOPs as well as like technology best practices is really important. Documentation, making sure that you're aware of what features are there and what gotchas might exist.
Defensible practices in our
Right.
system. So
Yes, exactly.
Beautiful, beautifully said. Thank you very much. Confidentiality. We are going to start under ABA Model Rule 1.6. Lawyers owe their clients a general duty of confidentiality. The use of some AI tools may require client confidences to be quote unquote shared with third-party vendors. As a result, lawyers must take appropriate steps to ensure that their client's information is appropriately safeguarded. So how does this play an important role in the delivery of legal services? Would anyone like to answer that for me? Angie, you look like you're curious.
So when you have large data sets, like discovery, usually you'll do it on through FTP site to keep it secure. Or you can, it's not like you're gonna mail opposing counsel 20 boxes or bank boxes of documents. They want it be discoverable. They want to be able to search it. They are not going to go through the whole process of scanning and putting everything in digital formats. So we do usually provide some FTP site or secured site or shared site for attorneys to sign on and download those documents and records. That's how we do it in-house. That's how our outside counsel, that's how we do it in-house to provide the documents that we have on our end is uploaded to the law firm's website so that they can review and analyze it.
And I know you play an important role with the executives at your organization, and I know you have in the past as well, whether it's chain of custody, understanding who has the data, how is the data at rest, how, data in motion, so forth. Data storage is an important aspect.
Yes.
With data breaches and such. Oh, go ahead, please.
And that plays on the communication aspect. I have the duty to communicate to upper management, the custodians, which are my internal clients, as well as outside counsel and our tech guys, like, hey, this is what we have to do. This is what we're looking for. This is the date range. These are the people that we have to pull the data from. And as well as with chain of custody, when someone leaves the company or retires and they're still part of the litigation, we have to make sure that all of that is secured with our on-site security, as well as our IT security has to review everything, because some of that data on there might be personal. And if it's personal, then we want to, assist that employee for getting those records off the computer or the cell phone or his USB ports. And I mean, there's a process and procedure, the chain of custody, to make sure everything is secure. And in case the court ever questions, like, hey, did anyone ever have access to delete documents from this cell phone or from this USB?
I love that point, and you're right with communication, but it would also, if I may, it also goes into competence as well, understanding the importance and the process of the data life cycle, if you will. Tanya, I'm sorry.
No, I just want to add in terms of like Chat GPT and bringing it to basically a lot of what we're dealing with now, being aware of the security protocols that are in place for the different tools, because you're dumping client proprietary information into a platform, and are you aware of where that may end up at the end of everything? And then also thinking about, are you using the different features like potentially encryption, or, what are you doing with the data in the cloud? Just making sure whatever you're doing, you're very aware of the security protocols in place for the data and where it may ultimately.
And to add to that, and I feel so bad for my service delivery folks, I think they're going to get a lot of calls, but like, push on your vendors to understand what their security protocols are, understand what they're doing to protect your data, understand what their SOP is if a breach happens, or if, well, not a breach, an incident happens. Sorry. But that's, technology can play an important role, not just in protecting that data, but then responding quickly and efficiently if anything does happen.
Yes.
And because that's a part of that confidentiality, it's not just, is the data protected, but can there be a response that mitigates damages and risk as soon as possible? So it's a two-factor thing, and wherever your data is stored, like well, I don't think everybody needs to know the answer to this question, but if you're trying to ensure confidentiality and that's your responsibility, then make sure that you have those tools to do so.
So if I could, how can AI be beneficial to assisting lawyers on their ethical duty of confidentiality? Whether it's, I've seen, AI for privilege review, identifying PII, so forth. Brittany or the rest of the panel kindly enlighten me on other ways in the audience.
Yeah, I'm very passionate about this. Prior to Relativity, I ran a data breach notification practice, so like really into it. But AI is very, very useful for making the notification process or the privilege process cheaper, more efficient, and more effective, which sometimes I think in the industry that we work in, effective actually might not be a great thing, because the more people you find that were breached, the more you have to pay to notify them. And like realistically, nobody wants to pay for this anyways. But if you're taking it from like an ethical stance, if somebody's data is compromised, then you should do everything you can to meet, what is it, best effort to notify. And AI, there's one particular model called named entity recognition, NER. It's called entity extraction. It's used in a number of different tools. And it's such a great way to automate the extraction of personal information that happens in a breach. And then the same kind of concept is applied in privilege, so that you can recognize if it's an attorney, if it's a paralegal, if it's counsel. And so those tools come with limited harm, and they're immensely, immensely helpful. So highly recommend embracing those, because they are just really great for this workflow.
Oh, I love NER. I would say that maiden name and so forth for name entity recognition, there's a multitude, the aliases, the misspellings, the multiple personal emails. Tanya.
No, I just want to piggyback off what Brittany said. Basically, I think she's highlighting, she kept using attorneys in conjunction with. We discussed on our number of our calls preparing for this, how, the big scary thing is it's going to replace attorneys and all, basically a lot of jobs, but in particular coming for attorneys. It's collaborative. We use it, we run it, we should control it. It should not stand alone without attorneys. So as you mentioned, it's how it helps us do our jobs better is what we're going for, to provide a better experience for our client and save money and be more efficient time-wise. But ultimately, just highlighting that it's used and works with us and how it helps us, not that it's replacing.
Yeah, all of my solutions required human expertise on top of it. So that was our layer of consulting expertise, and then the attorney layer of expertise, because both are necessary to ensure. I mean, there's like 58 different regulations, 54 in the US for data breach, and then you have all the hundreds of different countries and provinces and compartments and so forth. So you can't be expected to know every single thing. That's unrealistic. So having those multiple layers of expertise is how you make sure that you're doing best effort, whatever that means. So,
yeah. However you define that. Excellent. Thank you, ladies. I appreciate those thoughtful answers. And I can't stress enough, you're right, by utilizing AI for collaboration, as you kindly pointed out, yes, competent representation, back to competence again. A lot of overlapping. I would like to step into the rule of misconduct, 8.4, for those of you looking. So one interesting aspect of Model Rule 8.4G, as in Gina, in August 2016, AI adopted this quote, which prohibits the harassment and discrimination by lawyers against 11 protected classes. Rule 8.4G states that it's professional misconduct for a lawyer to engage in conduct that a lawyer knows or reasonably should know is harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, or socioeconomic status in conduct related to the practice of law. Yes, I wanted to read a lot of that one. I want to also point out that there are about 20 states that already have some variation of this. My understanding, South Carolina and Tennessee do not, but the great state of Illinois, where we all are right now, it does have this rule. So with that being said, can I ask the panel what their thoughts are when it comes to professional misconduct in the realm of the ABA rule, Model Rules of Professional Conduct for Bias and Transparency, Rule 8.4G, as in Gina. Whitney, would you like to step into this one?
Yeah, I mean, I've given a number of these talks lately, and the biggest thing is about when it comes to your, again, obligation of care around bias in particular. And there's many, many things that you should consider with AI. Bias is not the only one. But in this particular case, it's very relevant to 8.4G because models are only as good as the data that trains them. And if you're using a model that's been built by a primarily like cis white male group that maybe isn't too socially aware, then you get into problems where it's the output is racist, sexist, you name it, it's an ist and it exists. We saw this when we were building sentiment analysis. Our first results were very biased, heavily biased. And so it created this situation where if we released that to attorneys, then we couldn't really say that it was defensible because we knew that bias existed that skewed the results of the model. And so then we had to go back and look at it. And that's where I think the industry is gonna, I think there's gonna be a big focus on that in the future of like just how our models built, what is the training data, what's the diversity of the team, what's the responsible AI practices of the company so that you can have trust that you're using a model. There's transparency required, so you're not using a black box model, whether that's these conversations, it's blog posts, it's white papers, it's sitting down with the team and talking to them and understanding just what went into it. And I think that any software vendor that you're using for these sorts of tools should be like excited to have these conversations, exciting stuff. But that particular component of bias, I think, is really critical to get right now as we start to go into like the post-GPT world, where it's not just Chat GPT, it's GPT-4, it's the other generative AI models that are coming out, it's the open source models, it's people can make stuff on their computer now. So like we really need to get that right now so that going forward we have a framework of how to address these sorts of issues.
Oh, please.
Last month, the DOJ, FTC, and EEOC released that they are forming a joint committee to basically put forth that any AI that has bias in it, they're going to use their whatever their powers are to enforce it like they would on a human. For example, in the article I was reading, for example, if you're using AI in your systems for hiring practices and it's heavily biased, they're going to use their full authority to enforce against you whatever penalties you would have if a person was running that entire program. So the FTC, EEOC, and the DOJ basically are going to just basically charge whatever business company, what have you, with the same standard for using AI to do something. And if it's flawed and biased or what have you, you'll be penalized accordingly as if it were an individual doing. It'll be the same repercussions or what have you. I think it's the consumer protection laws and the employment laws they're going to be able to use to go, to enforce.
Interesting. Yeah, my understanding is that 80% of the hiring process, if I were to concentrate on just that, is automated. So it's rife with, so the EEOC is, I know, heavily involved in establishing more trustworthy, responsible AI, as is the FTC. Keep your AI claims in check, don't overpromise, etc. in their framework, which, yes, I have in the handwritten notes after this discussion. You could look at in more detail. But thank you. Go ahead, please.
So there's no way to remove bias entirely. And I do want to make that clear. The way that you do it is it's all mitigation, it's all risk mitigation, right? And so you need to understand what that threshold of bias is and what in particular causes the bias. I keep talking about sentiment analysis, but I worked on it, so it's all there. But we knew that if you said certain phrases or certain words, that would trigger a biased response. And then when we made those words neutral, we hard-coded them neutral, then it became the adjectives that determined what the sentiment is, which is how we were able to do a drastically reduced bias. I'm sure there's still some issues. We'll iterate as we find them. But when you're setting expectations with your vendors, just know that you can never know, or you can never eradicate it entirely, but you should be able to understand where that exists.
And that, yeah, that there's strong potential, and like you said, it's probabilistic that at some point there are going to be.
And sometimes bias is actually useful because you want a bias model maybe to serve up like inflammatory language. That's one way to do it without having like a toxicity detector or something. So there is sometimes use in that, but you have to understand that that exists so that you can use it correctly. And I think we have a lot of guardrails in place, but eventually people are going to want to build their own models, and which opens up the world to like a horrifying, just like it's one of those things where you start to talk about AI too much and existential dread sets in. And so I think like we need to make sure that those education piece for the bias is there so that as people start to experiment on their own, they're not like creating, you know, an apocalyptic scenario. Be super extreme there, but it gets really scary really fast.
I'm going to, thank you, ladies. I'm going to move on to supervision. After EBA model is 5.1 and 5.3, lawyers have an ethical obligation to supervise lawyers and, catch this part, non-lawyers who are assisting lawyers in the provision of legal services to ensure that their conduct complies with the rules of professional conduct. And you, what are your thoughts when it comes to supervision in the wonderful world
When it
of
pertains,
litigation?
when it pertains to AI, I mean, it's just vetting the data that has been put through like continuous active learning software. It's just spot checking, quality control. It's, you know, this is how you cover yourself in litigation in case like there is an issue. And this is how you're like, oh, the algorithm wasn't correct here because that's relevant material. Well, this isn't relevant. And then if you start finding like errors in your data sets, and you have to go back to step one and say, what happened with the AI here? Do we need to reteach it and run it through the data set again? It's better to catch that in the forefront as opposed to opposing counsel coming to you and saying like, hey, like this is completely irrelevant, or like, hey, you released some information that they shouldn't have. That's privileged and confidential to your business. So it's extremely important. One, to like spot check and vet and supervise AI, but you also have to educate the attorneys reviewing the materials as well. They're the ones that do help you and assist you with the quality control and spot checking all the data sets to make sure that the AI and the algorithms, everything has been accurate and it is producing relevant information for the litigation.
So if you had to explain, or, you know, an audit trail, if you had to explain to someone your process, your methodology, yeah, there was supervision and this is how it was laid out, even if AI was used. Yes, I like that. Thank you. Tanya, love your thoughts on supervision.
No, just in a real world scenario in the day of a life of a review, launching using AI. Watch it like a hawk, watch it all day, look at it a lot. Basically, you're going to know, at least in my experience, in the first 2 to 3 days, if something's going awry, either in what's being put in, the answers and responses will be skewed, you know, especially using like Row 1. You'll see it. I love the graphics. They are usually something that speaks great to internal case teams. They like to see that because they can demonstrate with your words what you're seeing, right? It's not going down, or it's staying too high, or when you're able to actually demonstrate that it's really working because you're basically seeing the results you want. But just to scoot back just a little bit, I think that it's really important to set the AI up for success. Like do whatever you're going to call it, the validation sample, the estimation sample, or whatever we're calling it for whatever tool we're using. Do that so that you can at least kick off the systems learning. And so when the review team starts, it's not just going into a data set where no one has made any positive or negative choices, right? They're getting pitched things from the start, and that'll be the best way. You sometimes have to force it. You know, no one really wants to sit through at a certain level and look through 500 documents, but I overstate the importance of doing so that you can get the best possible result, and it will be as efficient and cost effective as I'm pitching to be.
I echo your sentiment. When I started at Blue Star 15 years ago, we had armies of attorneys working on review. Now it's more AI based, of course, but I digress. I'm sorry. Brittany, did you have something you wanted to say?
You know, I think, you know, I'm talking about this from a product perspective. I haven't done an AI review hands-on in like 3 years, or 2 years. So I'm very rusty there. But I think it's important to understand, you know, just like what's a high risk model that you're using? It's a low risk, like adopting the AI EU Act, EU AI Act principles, so that you can understand what level of supervision you need to put on something. So if you're doing something where the model's high risk, sentiment analysis is high risk, and the results need that detailed supervision so that you can validate what's happening, make sure you have somebody who's highly confident, who understands the risk, who is, if you can get an expert on that in particular, that's going to make your review more successful. But if you're doing like, let's say we release a categorization for memes, you probably don't need a super confident person to verify that, or an expert. Let me say expert, not confident. Sorry. So that's pretty important, right, as a part of your overall picture of just what's going into active learning, review center, so forth.
I like how you pointed out, forgive me, I did. Looks like you have something to say. I was just gonna say, I love in our training that our prep calls, you're like, what is in high risk?
Yeah.
Yeah, underscore's point. I'm Tanya, I'm sorry.
No, I was just probably not too vigorously for this point, but
It's always going to be nodding. So it's like,
When you're nodding and smiling,
Got it.
looking at me at the same time, I'm like,
that's
oh,
a good
she
point to
has
make against the
something.
high versus low risk.
Forgive
So,
me.
ladies, I just want to interject and give you a time check. It is 10:47, just so you have
For
about
those
13
of you in
minutes.
Chicago, 12:47.
That's right. Sorry, 12:47. I'm in
Great
Cal.
state of Illinois. Sorry. Thank you. Appreciate that, Deidre. How about Tanya? I'm going to turn to you. We talked a little bit in our prep call about whether or not sanctions would be applicable if for lack of supervision. What are your thoughts on that particular airline or what have you that's been in the news lately? Please share.
To those who may not have heard, and I don't think there's a person that hasn't heard, there's a case out of New York, Avianca Airlines, personal injury case. Essentially, their plaintiff was on a flight. He was hurt by a service cart, injured his knee, filed a personal injury. Avianca Airlines basically said, you know, we're going to file a motion to dismiss. This is outside of the statute of limitations. The law firm, I forget the law firm's name, but the attorney of the issue is Schwartz. Basically, he briefed up the issue of statute of limitations, and I think he included about a dozen cases, and 8 of them were made up. He basically utilized ChatGPT to help him write the brief, you know, put his client's information in there, and it spit out some wonderful case law that he did not check. However, opposing did check and then flagged it to the court, which led us to last Thursday. They're in the sanctions hearing. There were some interesting things said last week, although we don't have a decision on the sanctions. I just want to make a few, because it kind of goes into what we're talking about. Basically state a few of the things that were said. The firm as well as Schwartz are advancing that, you know, no good could come out of, you know, sanctioning them at this point because, hey, you know, we're the poster children right now of, you know, how not to use this new technology. Okay, there's that. And then there was, and let me just back up, something that I don't know everyone's aware of because there's a supervision piece in here too. Essentially, Schwartz was not the attorney of record. And another attorney at the firm was the attorney of record because he was not licensed in that particular court. And there's a double failure there, right? If Schwartz didn't take a look, maybe the attorney of record should have, since his name is on everything being submitted to the court. And at that point, you know, now we're at the sanctions saying ignorance of the tool, you know, we're not familiar, whoops, but it really didn't fly. I read somewhere that there was even a point where it's like, I tried to look and thought maybe some of these were not published decisions. But then most of the way it was, I didn't realize it could make things up. So at that point, that's rife for sanctions, rife for
Yeah.
if we're not going to buy the ignorance excuse or the new technology thing, right? Because it goes back to the original competence, right? If you don't have the skill to be using something, get someone that has it. And, kind of when the world we're all living in now, we kind of all have an onus to know somewhat be reasonably conversant or familiar with technology. And again, find other individuals, because a quick Google search could have let them know it makes things up. I actually saw it make up an entire song in an artist's actual voice, and OpenAI is getting ready to shut that down, where you cannot, make a song out of any living artist right now, so just. Exactly, okay.
The making up thing, it's called hallucinations.
Thank you.
It will be coming up more and more as GPT is integrated into various different technologies. So I just wanted to share the terminology. The first time I heard it, I was like, are they doing shrooms? Like, what is the AI doing? Like, it was a very confusing moment for me. So sharing that information out.
Yes,
Sharing's caring. Thank you for sharing that.
it's right here, but not knowing was just, we'll see how it turns out.
Tell me, panel, about your favorite AI success story. I mean, today we're talking about the risks, but I do want to highlight a lot of the benefits and success stories and best practices. What would be a great success story that you'd like to share, Angie, Tanya, or Brittany? Is there a particular instance where it's easy about it?
Yeah, we've saved a lot of money utilizing AI when it comes to e-discovery and reviewing documents and reducing like and email threading, and all of that. Currently, I think in one of the cases that I'm working for, we've at least initial price tag of $1 million on the e-discovery, and I think we were able to bring the data down through AI to something more reasonable. It's near like 75% savings on that initial price tag, which our management was, not so happy to spend the money, but delighted that we were able to save it, because regardless, we were going to have to spend the money in e-discovery.
That's significant, 75%. Yeah, that's outstanding. Thoughts from the other?
Tremendous success with it. I would like to say, try to use it every opportunity I get. Clients tend to like it now that there's more education around it, and it's an uphill battle in the beginning because, what's this magic you're trying to use on my matter, and then, you slide in with your one case and two cases, and hey, everyone's using it, still not convincing, but, it's a different world than 5 years ago, in my opinion. It's not the uphill battle. People are now apprising themselves. So you almost go into the conversation with everyone having a bit of knowledge about it. And so I would say 30, 50, 60% on average, depending on which matter, to use numbers, 67,000 data set, code to 27 through various means, date, search terms, what have you, put in front of the team, 27,000, reviewed 11, and the rest were left. And that's the kind of way, that's quantifying at the end of it all, right? What did it actually cost to review those 11,000 versus the original 67 or even the full 27, right? And then just a flag, AI in the sense of the way we use it in review isn't always used to cull down or reduce what we review. Sometimes it's used to prioritize and categorize, because on a rolling production type of situation, it's really good to get the most relevant documents out there and to the other side. So you may end up having to review the full set because there's no way to cull it, and for whatever reasons, it's just not a good use for it. The data is not good for it, or the way the rules are structured, or rather the instructions, or for the matter, it's just not a good fit for it. But it just generally helps you either be more efficient and cost the savings, and not only completely efficient with being able to prioritize the most relevant documents up front and get them out.
The CEO of Blue Star, Greg Estes, says that AI is like a VIP pass. Just get to the front of the line, you get to where you need to go faster. I love that analogy. It is like a VIP pass in that you achieve a lot more.
Yeah, my example is essentially that. We have a lot of customers using relativity for investigations, and it's been a little bit of a shift in the paradigm of what the platform is used for. And I talked to a customer a couple weeks ago, and they had a bullying case, and they didn't really know where to start, right? Because bullying takes on so many different forms and language, and depending on where they are and so forth. And they were English speaking, so they decided to run sentiment analysis over it. And the first document that popped up was a pure example of bullying. And so they were able to use that document to then figure out search terms and figure out where else to take it, communications analysis and so forth. And I think we call them signals, and that's exactly what they are. They're flags. They say, hey, you might want to look at this. And the more signals we can surface, the quicker investigations go, the more effective they are. And, I did investigations. I know how many get piled onto your case. And so it hopefully will free up time and energy for people involved and make it easier to litigate.
Agreed. Thank you.
Ladies, we're sorry to interject. We do have a question in the chat room if you'd like to answer it. It is from A. Smith. Are there any additional mitigation efforts that should be taken beyond what's been discussed when it comes to AI and the protection of PII of minors?
Oh, that's a great question. It's very good. Is the question for
that can be for any or all of you. So whoever would like to answer it, and then whoever would like to, add to that.
Sorry, I just want to clarify. Are we talking about general use of like something like ChatGPT, or is this like if you have a data breach case where there's a minor involved, or like just a little more context, general use?
Right. So A. Smith said general use.
Happy to go first.
Yeah, I think so.
Okay. So in Italy, when ChatGPT was banned, it was in part because of the minors were able to access ChatGPT, and of course, that can be immensely damaging. We saw that with Vita, with their not that it was ChatGPT, but their chatbot was giving out advice that further harmed disordered eating, and teenagers are particularly susceptible to social media and AI-generated responses and so forth. So all that context. So what ChatGPT did was that they put an age verification in there. They require parental consent for using it, but like we all know from maybe not everybody, but from our teenage years when we wanted to look at something that was age blocked, that didn't really work out for the people trying to block it. It's very easy to bypass it. So do you think there's some advancement of technology that's required for verification? That's across the board. It's not just about age. We are going to need evidence verification and provenance, because you can do a deep fake. You can fake evidence with AI. We're going to need it for enabling the ability to understand, who's creating it, because a lot of this is black box, and it is kind of going into systems that we can't get access to. So I know that's a very long answer to say I don't know, but the technology just has to really catch up to where we are here in terms of security and in data protection in particular.
Okay.
Just safeguards is
Mhm.
whatever safeguards you can put in place. And it's going to depend on what you're using, what safeguards are put in place. Age verification, one instance, it may be something even more extensive for another type of tool. So I just think putting in safety guards to try to ward against minors being able to use or in return being harmed by it as well.
All right.
Well, ladies, we're at 1 o'clock Chicago Central Standard Time. I want to thank the panel. I want to thank Relativity and Blue Star for helping host this event. I sincerely hope that the audience found this to be informative and helpful. Be safe, be well, and thank you for attending.
Thank you, everybody.